Good morning and welcome to this morning's Knowledge Bank entitled Health Check Your Block. In this session, hosted by the Ringley Group, their team of experts will be talking you through how to health check your block, including service charge drivers, RTM and lease extensions, service charge audits, health and safety and building safety legislation, as well as some other points. If you have any questions throughout the session today, then please submit them via the Q&A box at the bottom of your screen, and the team will try to get through as many as possible at the end. Today's session is also being recorded and will be available to watch back later today with a copy of the slides. That's all from me. I will now hand you over to Carl Bradley from the Ringley Group to begin the webinar. Good morning, Carl.
Good morning. Hello, everyone who's joined us already. Thank you for joining us on this presentation. So yes, today we're doing health checking your block, and we will be talking about the agenda. Will start with service charge drivers, then move on to RTM and lease extensions, service charge audits, health and safety, asset registers, PPM, British standards, building safety legislation, and then defects. After that, we will have the Q&A, as we have been told already. So first of all, with service charge, my name's Carl Bradley. I'm one of the senior managers here. What we need to make sure when we're doing the service charge and the budget, that we are making sure we are fair and reasonable. This is the key driver. It's under Section 19 of the Landlords and Tenants Act. Everything has to be reasonable. So you have to make sure that you are charging people as they should be charged, and for any items they benefit from or have access to. You need to be very careful with this, and we'll come on to how you find that very shortly. We also need to make sure you are looking for your key items. So when you're on site, your plant items, for instance, are you considering your aircon that needs servicing, your lifts that need loader reports, need engineering insurance, pumps that need cyclical maintenance, or water tanks that need clearing out? These are all very key items that we need to understand from each other, and you would also need to know when you're looking at your sites. Don't forget the legislative testing. So if you've got AOVs, so automatic opening vents, any emergency lighting, Legionella testing, and the list goes on. You really need to be familiar with your site. You need to be familiar with your legislation. So if you've got emergency lighting, who's doing your flick tests? Who's doing your drain downs? Have you got a contract in place? How much is that contract? And will there be benefits of multiple buildings? How do you split that across those buildings? Then, of course, the hot topic for all property managers this year is utilities. When you've got gas and electric prices going through the roof, water bills, are you just communal? Do you have a single meter for the entire block? Do you have multiple blocks with a single meter? How do you charge that out? Please make sure that every year you're making 10 to 15%, and especially this year with 20% increase, we need to be looking into this. You also need to understand, of course, what you can't charge. So as an RTM, you are probably not at 100% membership. So not all owners or leaseholders are members. And as such, you can't charge company costs. So you wouldn't be able to charge through the service charge for directors and officers insurance, for end of year company accounts, for company secretary, etc. Because these are all company charges, not service charges. Okay. If you're an RMC, however, you can have the RMC charged to the service charge, but you would still need the RTMs or the freeholds charged only to those members. Okay, so how do we know what's needed? The first one, which is effectively your Bible, is to go to the lease. Your lease will have schedules that will tell you how often you should maintain things, when you should do internal, external decorations, who's responsible for windows, who's responsible for glass. Can you do window cleaning? Is a very common one, but you can't spend service charge often on cleaning people's glass in their windows for their flats if that glass is demised, for instance. We also look at documents such as the Section 106. This is the agreement between the new developer and the local authority to say what obligations they have. So you may have a site where you need to clean through the sewers and the jets and the surface drains twice a year, or you may have a canal nearby and you need to make sure you're clean and not leaking into that. So there might be testing you need to do. There's also the site inspection. So when we first take on a site, we do several site inspections. This is to fully walk through and understand exactly what is there. This is not only about looking at what pump and equipment is there, but also the condition of the equipment that is there. This also ties in very nicely to some regular site visits. If you're not looking at the site, or if you're not present on the site, you might not realize that you actually need to get your carpets cleaned, or you need to paint your interior walls, but not part of cyclical maintenance, but just as a one-off to bring the standards up again. There's the capital expenditure plan, which we recommend all sites have every 3 to 5 years. This will make sure that you are building the correct amount of money towards your reserves. So you know that in 10 years, you need a roof works done that's going to be £10,000, say. You know you only need to claim £1,000 a year rather than having a nasty lump sum surprise all at once. And important for us and for any other property managers out there is listening to the clients and the owners. So just because we aren't on site, we need to listen to them. We need them to tell us if they need extra works done, or if there's anything missing or any requirements at the site. And then, of course, we've got the setting expectations. So developers generally, when they first build a site, will set the expectation very low for the first ever service charge. In fact, there was one that I've got here of a Portman estate. The first charge, first year set by the developer, was £7.97 per square foot, and only 2 years later it rose to £19.39. So do expect your service charge to climb, especially when, as we will come across later, there is legislative changes as well as the gas and fuel prices. Okay, so how do we get our pricing? So we do regular market testing. We are looking at like news on the block. We look at online portals. We look at everything we can. We speak to brokers. We find out what the average market price is for the area we're in, for blocks with similar size. And we obviously try and match or beat that price. We also regularly tender. We won't do anything longer than a year. We need to make sure we are understanding how much we are getting for the job and what we are getting done. The value for money is also key. Just because it's the cheapest doesn't mean it's the best. So sometimes you do have to spend a little bit more, but it will actually help you with preventative maintenance, getting that little bit extra done per day than it does doing it all at once. We have to look at what is included in those contracts. So for instance, when we get cleaners on board, we also make sure that they are alerting us to any issues, right? Bulbs out, broken doors, everything. You don't want them just going around doing their job and leaving. So it's key to make sure you are asking the most of them within the price that you can afford. Do these companies offer out of hours support? This is a huge one for water, lifts, pumps, any plant equipment you have. You should be having a 24-hour contractor that you can reach at any time to come out and service your equipment if it goes down. We also look at preventative versus reactive. This is why it's great to be in at the beginning to understand where you're going, but it's also good to come in and know where you're at. So if we've got documents, we've got records, we can know where we are, we can plan, we can maintain rather than having to replace, because maintaining pumps, for instance, is a lot cheaper than having to replace them. Site-specific features. This could be, for instance, we've got one which is near an old petrol station. So you need to, a petrol cleaning piece of kit is on site, so it makes sure that it doesn't interfere with the water supply. This is very rare, but it happens. And as such, it's good to know that you've got this on site, which is why it's key to be there. Site staff, obviously, if you've got site staff, you've got to consider costs. You've got to consider whether it's fair, regular training, getting the most out of them with SIA, ICO, all these other sort of training courses that you can get them to do to pick up extra work at the site. We also look at the height of the building, because obviously different heights mean different legislative issues, such as do you need a wet riser or a dry riser? Do you have to consider window cleaning and all these options? And as well, of course, you've got the number of entrances, because you need to know how many doors are going to be used, how often, and how to maintain them. So obviously, if you've got any questions, please put them in the Q&A. I'm going to pass over now to Lee Hart, and Lee's going to be talking about lease extensions and RTMs. Yeah.
Good morning all. My name's Lee Hart. I'm a solicitor and partner of Ringley Law, and I'm going to be talking to you this morning about lease extensions and right to manage. So at the moment now, it's typically three types of lease extension: statutory, non-statutory, and a freehold relationship. So I'll talk you through each one. So under the Leasehold Reform, Housing and Urban Development Act 1993, a leaseholder, if they've owned their property for more than 2 years, can apply for an extra 90 years at a peppercorn ground rent. Another option is to apply for what we call a non-statutory or sometimes informal lease extension. whereby you reach agreement with the freeholder. Usually the lease will be for shorter periods. The freeholder will retain a ground rent of some type, and you'll also need to obtain your lender's permission, consent, what's called a deed of substituted security. And last but not least, the third type of lease extension is where you bought the freehold as a group of leaseholders through enfranchisement, and you'll give yourself 999 years at Pepcon ground rent. Again, you'll need in that process to obtain your lender's consent for deed of substituted security. So you would have seen a lot in the press in the last couple of years about lease extensions and how they're unfair and how unscrupulous freeholders are keeping ground rents. You may have seen about the Leasehold Reform and Ground Rent Act 2022, an act which came into force at the start of this year on the 8th of February. Under that act, under new leases, landlords can no longer charge a ground rent. You may not be aware, but although that act has come into being passed by Royal Assent on the 8th of February 2022, it's not actually in force yet. They have a period of 6 months to bring it into force. So we're looking at it coming law and enforceable by the 8th of August, but we haven't got a set date on that. When it does come into force, under new leases, the freeholder will not be allowed to charge ground rent, but and it is in the small words at the back. Some people missed it. If you were to extend the landlord extend an existing lease, the existing ground rent would apply for the rest of the existing term, and then the no ground rent would only kick in on the further extension to the lease. So just to be clear on that. So what we'll talk to you mostly today about is the statutory reform about lease extension. So at the moment, as I've said above, we've talked about under the Leasehold Reform Housing and Urban Development Act, we get an extra 90 years. What we're talking about is bringing into force 990 years instead. So for all intents and purposes, that's almost very similar to the freehold. It's going to be forever for all intents and purposes. They're also considering bringing other changes to leases. At the moment, there's only a handful of changes you can make to the lease. One is the extension to 90 years, another 90 years. One is reducing the ground to peppercorn. And there's also minor changes about what the landlord can do about developing the property, i.e. if they want to knock it down. But what they're proposing is to bring in a further range of further changes that the parties can bring in if both sides agree. They're also talking about the possibility, rather than extending your lease, is that you the right to buy out the ground rent, whereby you're effectively compensating the freeholder for the ground rent they would earn over the length of the lease. And under this process, you'd be compensating the freeholder for that. There'll be no ground rent to move paying forward, obviously, but at some stage, we need to look at extending the lease still. Moving on to right to manage. Now, under the right to manage, many of you may well be familiar with it. It applies to a self-contained building. You need to have less than 25% of the total floor area needs to be commercial. You need at least 2 qualifying tenants. The qualifying tenant is a leaseholder under a 21-year lease. You can only have 1 RTM per building, and certain unscrupulous freeholders have created a right to manage company, which prevents someone to do it again, unfortunately. Under the RTM, you're not required to have an annual general meeting with all the members. So the concern is that you take over right to manage, you only need just over half of the leaseholders to sign up. And the problem moving forward is that some leaseholders will sell and the new income people will not become members of the company because there's no requirement to. And obviously moving forward, the dwindling membership, there's a potential risk that once it drops under 50%, the leaseholders will no longer technically have the right to manage, and the freeholders has the opportunity to challenge their right to manage and say, hang on a second, you no longer have more than half of the leaseholders, therefore we no longer qualify. So the right to manage is no longer effective, and the management should come back to me as a freeholder. So we're talking about putting in place a requirement to hold an AGM, so there's more engagement with the owners over a period of time to hopefully to stop that from happening. And under currently, it can be difficult for leaseholders who are looking at right to manage how to get information about their fellow leaseholders. If you live in a big block, other than knocking on doors to find out who owns the property and doing land issue searches, your powers are fairly limited. You can make a request to the landlord. The landlord is obliged to provide information, but the timing of when they provide information is a little bit vague in the Act, and practically speaking, they do tend to drag their feet because they know they're going to lose the business, so they tend not to cooperate. So that's what we have at the moment. So under the Law Commission proposals, there's been a Law Commission consultation period which ended at the start of this year. So they brought in a long list of proposals. This is a summary of one of the bigger, more important ones, in my opinion. So they're looking at removing the need for it to be a self-contained building. So if there's an overlap across another building, perhaps you'll be better qualified. We're also looking at increasing the commercial element to 50%. So as I said a few moments ago, currently it's 25%. So if you have a shop on a basement and the ground floor of a property in the same footprint, you would need to have more than smaller 6 floors above normally to qualify. So what we're looking at changing it to 50%. They're also looking at reducing the requirement for one qualifying tenant. So at the moment it has to be, so that would allow houses to come into legislation. Obviously the legislation at the moment only applies to flats, where the current requirement is 2 qualifying tenants. So they're looking to bring it down to 1. You may have seen in the press earlier this year a case called Settlers Court. Settlers Court has overturned a judgment called Gala Unity, whereby it was determined that a right to manage could govern more than 1 block and shared areas. Settlers Court has flipped that and turned around and said, hang on a second, you can only manage 1 block and you don't get access to common areas. So if you're on a big development with multiple blocks and shared amenities, whether it be a swimming pool or gardens, etc., it can be quite difficult practically to separate the management out between those. So Settlers Court is an issue, and it's a little bit controversial at the moment. They're also looking at changing the problem of only one RTM per property. As I said a few moments ago, it is possible to form an RTM company which blocks as a sham and blocks the actual leaseholders from doing it properly. So we're looking at reducing that requirement, removing that requirement, and we're looking at also bringing in, as I said a few moments ago again, bringing in an annual general meeting just to kind of increase owner engagement and make sure that the owners are aware of what's going on and give an opportunity to participate in the management of the property and understand what's going on. And we're also looking at making it easier for leaseholders to get information from their landlords or current managing agents to allow them to take over the right to manage. So that's me done, and obviously I'll be available for questions at the end.
Hi, good morning. My name is Mary-Ann Bowring, and my subject that I've been asked to talk to you about to start with is service charge audits. So service charge management audits are not easy to get because you do need to have a significant number of qualifying leaseholders to be able to do so. So an interim step that a lot of people take is to serve what's called a Section 22 notice, which gives you access to all the accounting information that supports the last set of accounts. So I always think it's important for people to know that the interim step should be to do your Section 22 notice, ask for invoices and vouchers that support the last year's accounts. You need to do that within 6 months of the accounts being served on you. And then if you find enough things that are a worry, then that means that you can probably use that as a tool in order to, I suppose, flush out enough people to serve a proper management audit. Now, management audit is something very different from a service charge audit, because a management audit would be looking at management policy, management practices, value for money, whereas a traditional service charge audit or verification will only really be looking at is the bank rec right, are the invoices actually incurred for the right property. It won't be looking at whether the money was well spent, whereas a management audit will go into those aspects. There is, of course, a fine if the landlord doesn't produce either the Section 22 responses or a set of accounts. So it's always good to know. Those fines are a level 4 fine, and they're actually levied by the council as opposed to any other body. So you'd have to report that to your local authority if you hadn't received the accounts you think you're entitled to. By way of a bit of an introduction as to what the management audit may go into, first of all, it'll have a detailed look at the lease, head lease, Section 106 agreements, everything legal that constitutes how the site is run. It will then be considering whether the expenses are allowable under that lease, because just because you have an invoice doesn't mean it's necessarily provided for as permitted expenditure in the service charge schedule. It will then also look at things like apportionment as to did people pay the right reasonable costs that they should have done under the lease. And as an example, we're involved in an audit on Battersea Power Station at the moment, where we're challenging almost £5 million worth of expenditure. So the arguments can be quite shocking. Where there's public realm, things are much harder to decipher, but literally some developers do just seem to get it wrong and put a chunk of their, let's say, operational costs through the service charge. So you're probably following the newspapers that Telegraph is actually following what's happening on that particular site. In terms of developer costs, that kind of leads us into the subject of voids. Now, there is an ARMA guidance note on voids, and the lease will always say something too. The typical options in the lease will be either that units pay a fair and reasonable proportion of sold units, and that means that what's happening in the background is service charge percentages are being massaged until all units are sold to split the expenditure between just who's occupying. Other leases will say that the developer or landlord should treat all unsold units as if they were sold. And that sort of clause means that developers paying full voids for unsold units. Now, the calculation is quite tricky, because you're looking at what date was the invoice incurred, who lived there for how many of those days of the year, and how that apportionment should be dealt with. Another aspect, of course, is long-term qualifying agreements. That's any agreement that's more than £100 per unit per year. And of course, a lot of plant and maintenance agreements roll over. And on small sites, it can be quite easy to get stuck into that sort of pitfall quite early on. At Battersea, just an example there where the as-built drawings said that cradles should be used for window cleaning. Developer changed their strategy halfway through, but the as-built drawings are part of the purchase contract. So that leaves residents in a situation now where the cost of window cleaning has doubled. But in theory, the contract that they've purchased is the method on the drawings, which in conjunction with the purchase contract becomes contractual. Also, there's an aspect, of course, in early days about the repairs approach. Is repair maintenance, is repair renewal of the part, or is repair renewal of the whole, which means replacement? So there's a huge amount of case law on that, but there's always something to dig into there. So I think that's just a flavour of some of the aspects, but a management audit is looking for value for money, reasonableness of expenditure. It can be a precursor to the tribunal. The tribunal can be used as a method to extract additional information. For example, it's not uncommon to lodge proceedings, then perhaps stay proceedings for an agreed 6 months, while under proceedings, disclosure can then be sought. Fundamentally, the management audit is always looking to create what's called a Scott schedule. And a Scott schedule is simply a spreadsheet, but it has some specific columns in it Some of those columns will relate to the lease clauses, and then it will set out in one column, let's say the landlord's position, in another column the tenant's position, which therefore acts as a negotiation tool and tries to narrow down the issues and save trouble and time. So this is kind of a, let's call it a surveyor's audit as opposed to an accountant's audit, that can be quite enlightening depending on mixed-use schemes. Bigger schemes tend to fall into more pitfalls. Smaller schemes tend to be, let's say, isolated mistakes, but that's kind of how that runs through. Right, I'm going to hand you on to my colleague Leanna, who's going to talk to you about the asset register and the planned preventive maintenance schedule. So over to you, Leanna.
Hi everyone, I'm Liana and I do compliance here at Ringley. So what we're going to start to press on to is the asset register. So it's important to know exactly what's in your building, which plant, where it is, how to get to it, any installer information. All this helps. If there's anything wrong with it, you can give it to the manufacturers or you can give it to anyone who's going to fix it, and it helps them deduce the problem. It's also important to understand the guarantee that goes behind it, so you're not doubling up on paying something that's under guarantee and potentially ruining the guarantee as well. You also need to know the make and the model of it, in case you need to order specific parts, any serial numbers, etc. And the reason it's important to understand exactly what plant is in your building is because plant inside the building has to be maintained, and that leads nicely onto the British standards. So in the UK, there is a standard for each plant and how often it needs to be maintained legally. So for instance, a passenger lift has to be checked twice a year. Everything else has specific requirements. So if you don't know what's in the building, you don't know how often it needs to be maintained. And what it does, it keeps people safe. So it keeps the residents safe, anyone who uses it, and it just, yeah. And what we here have done at Ringley is we identify every plant within buildings and we have a planned preventative maintenance. And it's kind of like a diary, so we know exactly what's due when, and we make sure never to miss it. And the reason that all this leads into is ISO 45001, which is a standard for management systems for health and safety. So what this means is the goal of this is to save lives and to keep people safe. So not just anyone who's in the building, anyone who's visiting, any contractors, any bypassers. The goal is to reduce injuries and promoting and protecting physical and mental health. So here at Ringley, we've just achieved this, which means we make sure anyone who goes to the site is protected. Anyone who carries work out on the site has enough training and awareness as to the dangerous things that they're doing, and they can protect themselves. So some of the things that ISO 45001 covers is contractor risk management. So we have to ensure that anyone that we send to the buildings, the contractors have the appropriate accreditations to carry out the works. So not only does this protect them, it makes sure that the work they're doing is sufficient enough to keep the residents safe, and everything else that they do. So we also do accident incident reporting. So you have to make sure anything that is a near miss or an accident has to be logged. It has to be checked to understand if anything went wrong, why it went wrong, can we prevent it for next time? And it's continuous building and, you know, making sure everyone is safe. So we also have to carry out risk assessment method statements. So it's for anything that is high risk, any works that get carried out, such as working at height. Does the contractor know what to do to manage the risk, to lower the risk? Can it be reduced? Can it be observed? Everything like that. So here at Ringley, we've just achieved the ISO 45001, which we're very happy to do so. And it just promotes standard of management systems and health and safety throughout all of our buildings. So whether it's contractors, residents, owners, anyone, which I think leads on nicely to John Curtis, which goes on to fire risk and how to help the buildings.
Good morning, everybody. Lot to cover in a very short space of time, so we'll do our best to whiz through that as best we can. We're rapidly approaching the milestone of the 5th anniversary of the Grenfell Tower tragedy later this year, 14th of June, in fact. Guidelines, legislation and approach to fire safety is seemingly ever changing. Are these steps going in the right direction? Or just heaping added confusion onto the issues of funding and crisis for remediation impacting millions of leaseholders? Following the tragedy at Grenfell, the Royal Institute of Chartered Surveyors, RICS, alongside UK financing, came up with the EWS1. Everybody probably knows this term now. The mortgage lenders forced this onto people, and it's still doing so, and depends on what type of building you got, what type of cladding you have, whether or not you need an EWS1. This has caused arguments upon arguments, lenders refusing lending for remortgaging or initially mortgage lending. Post this confusion, there was uproar, and with the government changing their guidelines, the RICS decided to do the same. And so they adjusted the EWS1 to give a more balanced approach, meaning where you don't require, to try and clarify where you do not require an EWS1. It brought into play the argument over the height of the building and whether or not these are required. So for example, if it's 4 stories or less with no ACM or MCM panels on the building, you do not need an EWS1. So almost a year on, these steps do appear to have worked. Department of Levelling Up, Housing and Communities has actually revealed that data provided by 7 leading mortgage lenders in the UK shows that the vast majority of mortgage valuations for flats should not or do not require an EWS1. Whether they actually do so or not is an entirely different matter. The expert advice panel was released last year in July, which actually looked into the problem of the EWS1 and the risk-adverse nature of valuers requiring an EWS1 form when they do a mortgage valuation. Despite the fact that the vast majority of fires, actually 91%, were actually were in houses and bungalows or converted low-rise flats, other properties, 3 stories or less, basically. Only 9% of the fires in the previous 2 years actually occurred in blocks of flats of 4 stories or more. So the expert panel basically concluded that the risks in these high-rise buildings where EWS1s were demanded was actually so low that they shouldn't be automatically used. And what they concluded was that the risk-averse nature of the marketplace causing this confusion should be removed. The government got on the back of that, and on the 10th of January, various things occurred. You'll be hearing some of that a bit later on, but Mr. Gove then tried to change the approach to building safety, to buildings regarding the EWS1 approach, less risk adverse. A couple of things happened. They removed the famous advice note 14, which the industry had been using to guide how you deal with remedial works and the risks in a building. They required more, that what they were looking for now was a more practical and pragmatic approach to dealing with fire safety. Of course, what the famous thing was they did to protect leaseholders, blameless leaseholders in buildings over 11 metres, short-term enforcement of excessive bills and potential bankruptcy. The government were introducing a series of rapid measures. So additional £27 million thrown at it for lower-rise buildings, and the potential of bringing in the building safety bill, including in the building safety bill, retrospectively extend the legal right of building owners and leaseholders to demand compensation from their building's developer for safety defects. It started out at 15 years. The House of Lords decided it should be pushed to 30 years. We wait to see. Once the building safety bill comes through, it may be in there. It's an attempt to restore common sense to the industry. Unfortunately, however, everything seems to be awaiting the building safety bill getting royal assent. So having withdrawn the amazing, well-written advice note 14, the building advice for building owners, including fire doors and all the associated documents that were withdrawn on the 10th of January, replaced with PAS 9980. So from January of this year, fire risk assessments should include comments regarding the external envelope of the building and whether this is a risk to the informing the fire risk assessment. So not necessarily requiring an EWS1, but in a building that is more than two households, you need to do a fire risk assessment under the fire safety order and include a PAS 9980 review of the external envelope of the building. PAS simply stands for publicly available specification. It's a new code of practice for fire risk appraisal of external wall construction and cladding in existing multi-storey and multi-occupied residential buildings. It is a 183-page document and has been blamed for its lack of clarity. Now, one of the concerns that has been raised about opting towards the PAS 9980 is that it needs expert people to interpret that opinion on the external walls. And are we basically going back to the same situation we had with EWS1? Time will tell, but we at Ringley now are already and have done for some time included a review of the external wall cladding and situations with informing our fire risk assessments, and we have done for some time now. The golden thread. This came almost immediately out of the tragedy at Grenfell. Dame Judith Hackett said that the building control was not fit for purpose. And what we could or should have is a golden thread of information. How things were designed, how things were constructed, how things may have been altered during the life cycle of the building. That, in simple terms, is what the golden thread is about. The bizarre thing is that the golden thread should not be something different or new to you, because CDM 2015 required you to give that information across. It is so often not the case. Now, it's considered highly likely that the requirements within the Fire Safety Act, which got royal assent in 21, PAS 9980 and the Building Safety Bill Act will all install the teeth that Dame Hackett required immediately after the Grenfell tragedy. The Act has got royal assent, but hasn't been pushed into formal enactment or enforcement. The Welsh ministers have interpreted slightly different to that which in England. And at some time later this year, it is likely that the Fire Safety Act will become enforceable in England too. So in Wales already, they are looking at doing fire door inspections to flat entrance doors. And the fire safety order will alter to include that in residential buildings going forward. The government in the UK say that the Act should be brought into force shortly, but no date has been stated. The Building Safety Bill, possibly this year, but probably latter part of this year, will get royal assent. It will be the biggest and most fundamental change in building safety law for 4 decades. When that comes into act or get royal assent, unfortunately, it will take close to 18 months for those elements of the Act and the requirements on people, responsible people, to be enforceable. The Building Safety Fund, very briefly, has been made available, but it's moving so slowly, it is almost moving backwards. There are very, very few buildings that have been completed under the Building Safety Fund. There are a few that have funding but not proceeded because there are blocks on the actual funding coming forward, and any alterations to those works as they are proceeding has hit stumbling blocks on many of those that are already underway. I'll hand over to Mary Ann Bowring now for developer defect claims, which looks again at what Mr. Gove may or may not have promised.
Thank you, John. Well, Michael Gove did make a promise, and the promise was that he was going to try to get developers to contribute towards all things cladding. So we're waiting for that to find out what the reality will be. I think there's a genuine desire of government to approach things this way. Certainly in Wales, that has been the approach. You may be aware that Wales, unlike England, doesn't have a building safety fund as such. And the Welsh Government has been coercing developers there to do the right thing. So what Michael Gove promised was to extend the Limitation Act. That is actually part of the Building Safety Act that should be going through this year. It's been to the House of Lords a couple of times. There's still a question mark as to whether the proposal was, first of all, from 12 years to 15 years. It has been mooted. That some of the lawmakers in the land would rather it be 35 years, but I think that's quite unlikely. I think the likelihood is that the benchmark will have to go back to one or other set of building regulations. So whether that means it goes back to the 2010 building regs, 2008 building regs, 2015 building regs, it will definitely have to be pinned to one or other set of those, and when the fundamental biggest change was. I mean, you could still build properties in the 80s with 20-minute fire doors. By the 90s, it was 30-minute fire doors, and legislation has sort of continued since. So talking about limitation and warranties, there are various different redress routes, which I'm going to go through in a moment. The NHBC cover will only cover you, or most building guarantee covers will only cover fire door issues for 2 years. But they will cover things that are building regulations such as compartmentation for 10 years, and that's under what's called Section 4 of a typical policy. The 3-year route is more around negligence advice from surveyors. The 6-year route is around documents by deed, and 12-year by contract. So moving on, here is the detail, probably the slide that some of you are desperately wanting to understand more about. Defective Premises Act means wrong materials, wrong workmanship, not fit for purpose. Limitation on that since 72 is 6 years. It is the Fire Safety Act that's intending to enhance this and basically alter this act to give 15 years. The Latent Damage Act only occurs to negligence cases, so that's more about the method of installing the right materials in the wrong way, as opposed to the wrong materials, the wrong specification, which would be defective premises. So that's the key difference between the two, but you only have 3 years after discovery. So we are involved in a number of cases where perhaps the company discovered at the time the developer was the directors for the company, but the current directors didn't discover until much more recently. Sadly for them, the company is a legal entity, so it would have been the date that the company discovered, not the date that subsequent directors discovered. Breach contract claim, that's a typical route for class actions. And that's basically what makes a contract is your purchase contract, which will normally refer to the as-built drawings. And the as-built drawings will, of course, tie into building regulations because they should have been approved by either local authority building control or private building control. A breach of contract claim, however, only applies to the original owners. And this is where things get difficult over time. Because, and the reason for that is that if I bought the property first person, then those developer contracts, a purchase contract applied to me as a person. And if I sell the property to you, then your purchase contract is between me and you, not developer and you. So breach of contract claims don't transfer down the line. So often we're in a situation of having to work out how many people in a building are still the original purchasers. That in itself can be quite expensive because you may have to do land registry searches of a number of properties to find that out. So breach contract claims normally last for 10 years because leases are made under deed. So that was that. Negligent survey advice. Arguably, you may have negligent survey advice if you bought a property in a building and had more than a mortgage valuation. You need to remember that mortgage valuations are not for the purchaser, believe it or not, you pay for them, but those mortgage valuations are for the for your lender. They have a duty of care to you, but contractually you're paying for the lender's survey. However, if you go one stage deeper and have a building survey or a home buyer's survey, then that is for you. You are the client in that transaction. So the types of advice there is if the building, let's say, had defective or condemned cladding materials on it, and it was pre-EWS1 certificate, and your valuer or building surveyor didn't notice that or suggest you get that investigated, arguably he could be negligent. The challenge here, of course, is that the survey would only relate to your home, your property, not the common parts. And most of the problems that the industry is reacting to at the moment are indeed the compartmentation, which relates to the wall, the ceiling, and the fire doors in the communal area, and the fire doors that connect your flat to the communal area. We already have it as law in Wales and are running around inspecting residents' private front doors. That will also be law in England when the Fire Safety Act becomes law later this year. Next piece of legislation is the consumer rights legislation. So effectively, that's again another route for smaller claims, not bigger class action claims, where perhaps what you've been sold is not fit for purpose. So there is that route. And we are in a situation on some sites where we are considering claims for breach of directors' duties against a developer, because if the developer sat as the management board for the first number of years and chose to not take action on things that they built that ought to have been taken action upon, then arguably they're in breach of their fiduciary duties of care. A good example on that could be where they haven't had the fire doors inspected. You know, we have some sites where the cost of fire door defects is new sites to us, but in the region of sort of £600,000, and door sets 60% having to be reinstalled due to various problems. So, you know, these are not necessarily small numbers. My personal experience of developers litigation is involved with a number of different barristers who would normally weigh up claims, and they would weigh those up on the basis of each head of claim and its likely success factor. The problem with class actions is not only do you need to get enough owners involved to raise a fighting fund, it will blight the property, which means that effectively for the next couple of years, nobody will be able to buy or sell easily, because nobody wants to buy into a block with unlimited litigation. And also developers do have I suppose, a bias to appointing the most expensive lawyers who will deliberately tie things up in paperwork and procedure because it's in their advantage to outspend leaseholders. So these cases often don't get to court because they just want to exhaust the money of the leaseholders. So unless each leaseholder is willing to put between £3,000 and £5,000 into a fund to fight litigation, often it isn't necessarily the easiest way. We're all desperately hoping that Michael Gove will do the right thing. And the industry is desperately lacking what was proposed some years ago, which is a new homes ombudsman. If one was cynical, I suspect the reason there is no new homes ombudsman is because the government desperately wants houses built and therefore has to be nice to developers, and developers don't want a new homes ombudsman, or most of them don't, mostly because there is no simple adjudication to major issues that require evidence being sifted through by experts, whereas the ombudsman process generally is normally simple. Did something happen? Did it not happen? How hurt is the other party? So there are fraught with legal difficulties to be planned for. The other area just to touch upon is, of course, warranty claims. Warranty claims are never quite as easy as it says. Warranty claims are insurance backed, and most insurers want to, well, the consumer would say they don't want to pay, the insurer would say they work into the letter of their policy. Whichever way you look at it, it means that it is difficult to line up your ducks to prove things. Warranty claims are certainly not a managing agent's day job. The managing agent's day job is to manage and arrange the status quo in the management of the building. It's not to take developers to court. It's not to take the NHBC claims on either. NHBC claims are an extremely specialist area. All policies tend to come with roughly £950 per owner excess. So by the time you've added that up, you really need to consider how widespread is the area, what is my evidence, are we really going to get anywhere with that? So I've just put a little summary there of the types of issues that are dealt with at years 1 to 2, 1 to 10, or 3 to 10. But effectively, it's not dealing with any mechanical, engineering and plant issues at all. This is structure, foundations and building regs compliance only. I think we're up for our questions and answer time now. So Anthony, you chairing these?
I'm going to jump in now. Marianne, I can see that we've got a couple of questions. So the first one here says, my landlord sent me 3 versions of a service charge demand for the same year. The figures were different on each. We were only allowed 6 days to consult on charges. Is this allowable?
3 budgets or 3 demands?
3 service charge demands.
Okay, well, difficult to answer that question without more information. In theory, there should be 1 budget unless the budget is substituted for a later budget, and how many demands you should have would depend on your lease. So he shouldn't be demanding the same thing more than once. But in theory, if the lease said 2 demands, you get 2 demands. If it said 3 demands, you get 3. What it suggests to me from the question is that there's been changes through the period, because 3 is an unusual number. Demands are normally either 1, 2 or 4 in sequence.
I think Anthony, who submitted the question, has just put another comment that said there were clear errors in the figures.
Okay, so effectively they're substituting an incorrect demand for a correct demand in their interpretation.
Yes.
So the mechanics or the machinery of the lease will depend on whether that's allowable. So the lease will have specifics as to timescales, as to when budgets are supposed to be served, when demands are supposed to be served, etc. In some leases, it can be fatal if demands have failed to be sent out in advance of the date they're due on. In other leases, it's not fatal. However, the bad news is even if the demand was fatal, if the person serving them knew what they were doing, they could, in theory, collect the whole lot as a deficit, because if a demand is deemed to be non-existent in law, then you wouldn't have the money. So therefore, you would have spent the money and have a big deficit. Your deficit would be collectible under Section 20B notice or via the accounts.
Okay, lovely. I mean, I'll be sending out your contact details with the slides anyway, so if anyone wants to follow up further and contact you directly, then they'll be able to do so. We have another question that says, once the lease can be extended to 990 years, what will the minimum cost for a lease extension be?
Yeah, fair question. The theory is if you've got a 999-year lease, then it is a virtual freehold. And from a valuer's perspective, we tend to apply 1 to 2% enhancement on the normal leasehold value as to a virtual freehold value. So you're no longer paying to compensate for ground rent, because the ground rent becomes a peppercorn on a 999-year lease. And in theory, the other main part of the lease extension is marriage value. That's diminished because your lease is well over 80 years. And the third component is the value of the property at the end of the lease. And because that's so far in the future, 999 years, effectively that's nothing. So the market tends to have a perceived 1 to 2% enhancement for having a share in the freehold company. Generally, you'd pass a resolution of your management or your freehold management company to say on what basis that you'll grant lease extensions for those, grant shares in the freehold to late entrants as a constitutional matter, and then that makes a clear management policy for your building.
Okay, lovely. I have another question from Marie. Should a managing agent suggest the leaseholder should seek legal advice regarding what claims they should make against the developer, or should the managing agent become involved in this?
The managing agent's job is to signpost matters beyond their day-to-day managing and arranging the services to the buildings. So managing and arranging services to buildings does not include collecting forensic evidence against a developer. The managing agent has a role to play in terms of communication and let's say signposting to professionals and assisting the client or the director of the management company with additional understanding of what those experts are saying. And the managing agent should presumably attend those meetings alongside the leaseholders with the experts, because they've obviously going to be responsible for helping make representations when properties buy and sell. But no, the managing agent is not there to manage developer claims. It's such a specialist area. If you ask them to do it, they would probably do it wrong or badly and possibly prejudice your claim. If you've got issues that serious, you need to start taking on or building up what you think is the right team to advise you going forwards.
Okay, thank you very much. Another question, can a section 22 request a nominal ledger with receipts? What about contracts, etc.?
There is case law that says that documents need to be sufficient to understand the invoice. That's a 1999 case. So there are many managing agents which will only provide an invoice, and you'll end up in an argument because the invoice doesn't say enough. So what makes up that invoice includes, in theory, the contract plus the purchase order. But first touch, most agents are reluctant, stroke unwilling to provide that, but there is some case law that helps.
Okay. And then I forgot one that's just come in the chat. With the imminent changes to ground rents, what incentive is there to acquire freehold titles? And is a possible outcome of the imminent legislative changes going to push the values of older developments higher, where ground rents can still be collected?
So I think that relates to what we're speaking about, the Government Act coming in earlier this year. It's not coming into force until later this year. So to answer your question, it's difficult to know. So is there a question I can read? Is it on the chat?
Yeah, if you look in the chat screen, you'll be able to see that one.
I think there's going to be less incentive on people to buy freeholds effectively, because they're going to have less investment opportunity longer term.
Okay.
The values always higher.
Yeah, I mean, in terms of value perspective, freeholds are valued for two things. They're valued, one for the ground, or three things actually. One for the ground rent income, and if that disappears, then that part has no value. Two, for the right to place insurance and take the commission. And we all know that freeholders' commissions can be quite high. And four, for the future value of lease extensions. So certainly we are in a consumer market and the opportunities for freeholders are diminishing. I mean, some of these aspects we've been blogging on, because as good as that sounds, there is also the challenge where perhaps a freeholder may manage a building from a perspective that you do what needs to be done according to the British standards. You decorate the block when the lease says you have a capex plan to plan for the future and your reserve fund is reasonable. Whereas some blocks, not all by any means, but some blocks under leaseholder control will scrimp and save on reserve funds, probably double the period in which redecoration should be carried out. And therefore you can end up with this argument between, is it professional management or is it cash flow management? And if you're not managing to protect the building for the long term, then in the longer run, values will fall. The government was hoping that this would push the world onto common hold, which is really a European model. I think in this country we're still very tied to the feeling of what a lease is. And common hold comes with its own challenges, because when our leases end, we all have, I don't know, 800 square foot of airspace in a building that might be knocked down, and have to work out as a bunch of friends how to go and rebuild a building together. So I'm not necessarily an advocate saying that's any easier, but land law is a very complicated field.
Okay, thank you. Hopefully that answers your question, Philip. We have one more here from Anne. My building is coming up to 5 years old. I'm on the ground floor with the lift backing onto my kitchen wall. Since moving in, there has been water coming into the lift pit. This could eventually affect my flat. Can I claim against the NHBC, as this has been a problem since the block was built?
Okay, so it depends where the water's coming from is the short answer. I mean, if it's a roof, flat roofs are covered for 1 to 2 years, so you're out of time. If it's a pit, and that includes gutters, if it's a pitched roof, then your timescale may go longer. There may well be roof guarantees. However, perhaps it's a weeping pipe on a riser, water pipe on a riser cupboard, or perhaps it's a neighbour's shower or something. So without knowing that, where it's coming from, it's not difficult to get a company to trace the leak. It's not difficult to get sonar testing of water pipes to find out where it's coming from. You've got to identify your source. Alternatively, if the lift pit is literally next to your flat, it may be that there should have been a sump pump installed in the lift, and perhaps there isn't. That may or may not be a developer omission, and only the as-built drawings would answer that question. But to be honest, my gut instinct says really it's more of a maintenance stroke managing agent issue, and you need to make sure that they take care of you.
Okay, perfect. I think that's all of the questions then, unless anyone's got anything else they want to submit.
Silence.
No,
I guess that means, I mean, that was quite a lot of heavy.
That's usually a good sign.
Yeah, sorry, I was just going to sum up for it.
Yeah,
There's quite a lot of heavy material today, but it was really meant to be a very short highlights to signpost you onto some of the legal changes afoot and coming in very quickly. And also, whilst all things developer are very highly in the arena being discussed in the national press, etc., perhaps that just at least empowers people to know some of the things available to them, even if that means that sometimes you have to explore them and take alternative action. But hopefully no leaseholder should be feeling we don't know what is possible, and the aim of this morning's talk was to try to deal with that.
Yeah, thank you so much. And thank you all for your time today, everyone from the Ringley Group. I think that's been really helpful. And as I mentioned earlier, the session has been recorded, so I'll make sure that's available for everyone to watch back this afternoon. I'll also send you a copy of the slides. And yeah, so all that's left is just to say thank you again to you guys, and thank you everyone for joining us today.
Thank you.
Thank you. Goodbye.
Bye-bye.